Hi, everybody. Welcome to Peoria Proud teaching series for InQueery. Tonight we are talking about power of attorney and wills. We have two presenters with us tonight. We have Joshua Herman, who will be joining us in a little bit, and we also have Catherine Chatterton, also here. So, Josh, a little bit about him. He's a partner at Miller Hall and Triggs LLC and has practiced law since 2008, concentrating in municipal law, school law, employment law, commercial law, and related litigation and arbitration. Josh received his bachelor's degree in 2003 from Bradley University in Peoria, Illinois. After his deployment to Iraq with the United States Army, Joshua attended the Chicago, Kent, and University of Illinois Colleges of Law. While at the University of Illinois, Joshua received the Best Trial Advocate and Best Oral Advocate awards in addition to being on the Green National Moot Court team. In 2008, he obtained his Juris Doctor from the University of Illinois College of Law, graduating with summa cum laude and receiving the Rickert Awards for Excellence in Advocacy and Excellence in Academics. Joshua is currently the president of the Peoria County Bar Association, and he enjoys working to better his community and the legal profession. Catherine is an associate attorney at Miller Hall and Triggs LLC, concentrating in business law, real estate law, and estate planning and administration. She graduated summa cum laude from Bradley University in 2018 with her bachelor's degree and earned her Juris Doctor cum laude from Chicago Kent College of Law in 2021. Catherine is committed to making complex legal concepts accessible and empowering clients to make informed decisions about their futures. We are going to hand this over to Catherine first. Josh will be joining us in a little bit. So with that, Catherine, please go on and take it.
All right, I'm going to share a presentation. As stated, I'm going to be talking about life estate and planning considerations. So hopefully, can you see my presentation? Okay. I'm skipping ahead a little bit here. So I'm going to be talking about three primary documents that give a chosen person power over your affairs in the event of your incapacitation or death. Incapacitation basically just means when a medical doctor deems that you are no longer capable of making decisions for yourself. So that can be from some kind of physical incapacity, like if you're in a coma, or some kind of mental incapacity, like if you have dementia, for example. So for a power of attorney for healthcare, which is one of the primary documents, you appoint an agent for your healthcare matters. So if you just think of all of the powers that a parent has to make medical decisions for a child, that's basically what you're giving your agent. And it's most useful in the case of an emergency created by a disability, like I said before. And the form has you choose when the agency becomes effective. It's important that if you do choose to designate a power of attorney for healthcare, that you state when you want the agency to start. Because if you don't, it will start immediately, which you may want to immediately start giving someone else the right to access your medical records and keep track of that, but you probably don't want to give someone the power to make your medical decisions in most cases, unless you are incapacitated. The form also allows you to limit choices your agent might make. So if there are specific medical decisions or procedures that you're not comfortable with, you can put in the form that you are not comfortable with that, and then your agent cannot do that. And this agency may be revoked at any time, but terminates automatically upon your death. So who can be your power of attorney for healthcare? It should be someone that you trust to make healthcare decisions for you. It has to be someone who's over the age of 18. It should ideally be someone that you trust and someone that would not be too upset to carry out your wishes. So, for example, if you think that your partner's judgment would be clouded if you were very, very sick and a hard decision had to be made, that might not be the best choice as your person for a power of attorney for healthcare. And also, it cannot be a medical provider at the time that you're receiving treatment. So, for example, my sister is a nurse, and if she's not my nurse, she can still be my power of attorney. But if she were my nurse, then she could not be my power of attorney because that's not allowed. Um, and to effectively pick a power of attorney, there is a statutory form for a healthcare power of attorney, and you basically just fill it out, sign it, and then you must have a witness who signs it also. And that person has to be at least 18, cannot be a healthcare provider to you, and cannot operate the facility that you're in if you are incapacitated and in a hospital or a care facility. And it cannot be basically a relative, descendant, spouse of you as the principal or your healthcare agent. So a lot of times, if you went through an attorney's office to get a power of attorney for healthcare, they would have a third party witness that is included in that. And that's how you would get that person. But in other cases, you might have a friend or just someone who's not your doctor, not a relative, and not a relative of whoever you're making your agent. Oh, and the agent cannot be the witness either. So the next document is a power of attorney for property. This allows you to appoint an agent for property matters, which are things like real estate, bank accounts, tax stuff, that kind of thing. And there is a list of powers in the form, and you can strike out any of them that you don't want included. So, for example, if your real estate is really important to you and you don't want anyone to sell it without your express permission, you could strike out real estate and say that they do not have that power. This is also most useful in the case of an emergency created by a disability. Um, and unless you limit when the power of attorney is in effect, just like the healthcare power of attorney, your agent may exercise the power before you become incapacitated. So you want to set the start date in the form more than likely to be when you're incapacitated, unless you want to give someone the power while you are still capable of making your own decisions, which you can, but just most people don't. And this appointment can also be revoked at any time and terminates upon death. So again, this should be someone that you trust to make decisions for you. Someone, they have to be at least 18 years old, trustworthy, and logistically, it makes sense for it to be someone who is located close to you. So while you can appoint someone who lives somewhere else, especially in this day and age when it's pretty easy to do everything electronically, most people would pick someone who lives, say, like in the same state as them or something like that. And again, no medical provider or healthcare provider can be an agent. So this also has a statutory form that I've linked in the presentation. And you have to sign the form. And again, there has to be a witness. And it's pretty much the same restrictions for the witness as the healthcare power of attorney. It can't be the agent or a successor agent who's the witness, can't be parent, sibling, spouse, descendant of the principal or agent. So it kind of has to be an objective third party who doesn't really have an interest in the contents of it. And Josh will discuss living wills when he presents, but you also want to consider a last will and testament, which directs how your property and assets are distributed after your death. A last will and testament only takes effect after your death versus a living will, which discusses your preferences for medical care and life-sustaining treatments upon your incapacitation. So that's the difference between those two documents. If someone passes away without a will in Illinois, their property passes through intestate succession. And those laws provide that when someone passes away without a will, their property goes 50% to their legal spouse and 50% to their descendants. If the decedent is not legally married or doesn't have children, their property goes to their parents or siblings in equal proportion. And a few things you want your will to cover. First, you want to name your beneficiaries. It should say anyone that you want to receive your property upon your death. And this is one of the main benefits of having a will versus letting your property pass through intestate succession, because as I stated before, it it's pretty limited who gets your property if it passes through intestate succession. Whereas if you're naming your beneficiaries, they can be anyone. It could be your friends, a charity, your cousin that you're closer to than other family members, something like that. You can really customize how your property is distributed. So that's a big benefit of a will. And your will should also state who will be entrusted with administering your estate. And a lot like the healthcare and property powers of attorney, it should be someone that you trust to carry out your wishes and effectuate the terms of your will. And if you have minor children or adult dependent children, your will should also name a guardian for them, should one be required upon your death. And the legal requirements for a will to be effective are for it to be in writing, signed by you, and signed by two witnesses who are not beneficiaries. So this is something that you can do on your own. A lot of people seek out a lawyer's services because that way you can make sure that what you want is really in the document is going to be carried out. And also it gives a lot of people peace of mind just to know that it's done correctly. But technically, the three legal requirements are in writing, signed by you, and signed by two witnesses who are not beneficiaries. That was all I have for my portion of the presentation. Did anyone have questions, or should we wait until Josh joins us? Oh,
I
Looks
am
like
on if
he's.
you can hear me.
yes.
So we are going to go ahead and then move this over to Josh. Let you talk about the living wills side of things. So go ahead and take it away.
Thank you, Catherine. Were you able to give a quick overview, or are we still waiting for that?
We are still waiting on the overview.
Thank you. To all attendees, I apologize. I learned that my home has terrible internet connection and not enough bandwidth for this. I also learned that I can get to the office 5 minutes faster than I usually do. So I'm glad to be joining you this evening. Let me share my screen so we can get going. Okay, well, that didn't work. Let's try that again. Are you see advanced directives? No. Entire screen. There we go. Still not coming. Huh? Do it a different way. Oh, it almost looked like it was working.
Yep. It looks like we can see your slideshow now.
That's great. Let me see if I can make that bigger for everyone. we're going to take this and run with it. Our goals today were to talk about advanced directives, which include living wills, as Catherine just talked about, powers of attorney for healthcare. It also includes a few other things, but our main point tonight was to share that when dealing with advanced directives, which is what all of these are called, directives while you're still of sound mind and body before you're unable to make decisions, is plan now. While you can, when you can, tell those who are able to implement your will and certainly willing to implement your will now while you can. And then annually, you'd like to revisit and review those plans to make sure they're up to date with your most current desires. There are four main types of advanced directives. The first is the living will, which I'll be talking about in just a moment. Second is healthcare power of attorney. These are the two main subjects for this evening's presentation. There are also two others I wanted to touch on very quickly for you. The first is the mental health treatment preference declaration, and second, the practitioner's orders for life-sustaining treatment. First, the mental health treatment preference declaration is really just a long-winded way of saying that while you are now of sound mind and body, you can commit yourself to receiving electroconvulsive treatment or psychotropic medication if you have a mental illness that might require that treatment, and you now, while in a lucid state, want to commit to doing that, or committing yourself for up to 17 days of treatment now while you're in a lucid state, rather than waiting until some later time when others might think that you are unable to do so. We're not going to spend more time tonight talking about that. There's a statute that relates to this, and there's a link in my slideshow which will be available to all of you that describes further how you can engage in such advanced directives if this is your desire. The second that we're not going to spend much time tonight on is practitioner's orders for life-sustaining treatment. In other words, this is a no CPR order. This is issued through the Department of Public Health by the state of Illinois. There's a form for it. If this is something that sounds like you'd like to have or explore further, you can review the state of Illinois' website for that. With that said, we're going to jump right into the various topics that we hope to tonight, which is first, a living will. But we'll do it second because Catherine was kind enough to start the presentation. Living wills. The state of Illinois recognizes that people have a fundamental right to examine and control the decisions that relate to their own health care in instances where they suffer from a terminal condition. I want to be very clear. The only way you can have a living will is if you have a terminal condition. If you have other expectations with respect to the health care you're going to receive and you do not suffer from a terminal condition, I advise you to go the healthcare power of attorney route. This will allow you to enable someone to make decisions on your behalf if and when you're unable to do so. You can convey your interests and concerns to them. If you do not have a terminal condition, living wills are not available to you, at the very least to be effectuated. You can fill one out before you are deemed to have a terminal condition if you anticipate that's going to come or you want to have it in your back pocket. But the best and most safest course of action to ensure your desires are followed is likely a power of attorney for healthcare if you do not have a terminal condition. That said, patients with terminal conditions can establish a living will that allows them to provide a written directive to their physician to withhold or withdraw death-delaying procedures. Breaking it down, it is a written declaration of a sound-minded adult. Think lucid, able to make informed decisions for themselves. They must be 18 years of age or older or emancipated. In order to be given legal effect, they have to be suffering from a terminal condition. And it is a directive that death-delaying procedures be withheld or withdrawn in certain circumstances, and it must be witnessed by two individuals who are 18 years of age or older. There is no consideration for emancipated individuals for witnesses, and it cannot include your healthcare provider. So what is a terminal condition? A terminal condition is an incurable or irreversible condition that means that death is imminent, and the application of death-delaying procedures only serves to prolong the dying process. So what's a death-delaying procedure? It's any medical procedure or intervention which, when applied to a qualified patient, in the judgment of the attending physician, would serve only to postpone the moment of death. This, practically speaking, can be any life-saving measure that will be applied to an individual with a terminal condition. Note the way that this is defined in the judgment of the attending physician. This is important because if the attending physician does not find that the procedure would delay death, then they may not effectuate your living will. Please note a couple things. One, these procedures are specifically included in death delaying procedures. So if when you look at them and you suffer from a terminal condition, you decide you would not like to be subject to them, they would be a reason to impose a living will. Second, this can never include the provision of nutrition and hydration. That will always be provided by your physicians. That said, if your physician believes that they would not be able to effectuate your living will, they're supposed to notify you as soon as possible so that your care can be transferred to someone who might. Another caveat that we need to make clear under the statute is if the physician believes a living fetus in the terminal patient might develop to term, they can choose not to proceed with exercising the living will. Again, as I mentioned, any attending physician who believes they will be unable to comply with your will needs to notify you as soon as possible so that you can get care from someone who will. Just as important as governing your own care is the fact that Illinois law allows you to revoke a living will. And while you must be of sound mind and body to establish a living will, you need no longer be of sound mind in order to revoke it. The law allows pretty extraordinary measures by pretty extraordinary people to revoke any established living will. So we won't get into too much of the details, but any indication from the patient that they no longer wish their living will to be in effect will be sufficient. Please note that physicians have responsibilities under the living will law as well. The attending physician, once notified of the living will, must make a record in the patient's records that they are in terminal condition. So they, their assistants, and all future medical providers know that your living will is a qualified directive that should be followed. A few additional considerations I just want to make clear for everyone before I wrap up on living wills. One, for those of you concerned about it, exercising a living will not be considered a suicide. Avoiding death delaying procedures is not committing suicide. Two, no declaration or denial will change your life insurance policy. Any person who passes as a result of their living will be passing as a result of their terminal condition, not because of their living will. The only thing a living will does is prevent or deny the provision of death delaying procedures. There is no limit or other legal right or responsibility regarding withholding these caregiving options. So any medical provider who is following a living will not be subject to any liability as a consequence. All of the powers under the Living Will Act are cumulative, meaning that they add on to all of your other rights, including healthcare powers of attorney and other advanced directives. Finally, the Act does not prohibit mercy killing or allow deliberate acts or omissions outside of the living will. So it is only according to your will that the living will authorizes anyone to act or withhold action. And finally, Illinois recognizes living wills enacted under other state laws. With that, I'd like to make clear that there is a lot of information the state of Illinois provides regarding advanced directives. Our slideshow provided today includes links to various statutes if you'd like more information, and more importantly, the statutory forms. You don't need to hire a lawyer in order to affect these interests you may have with respect to your health care or future care. You only have to fill out, at a minimum, the statutorily provided and required forms in order to affect that health care and have been completed correctly and witnessed by the appropriate people. But if you feel confident and comfortable in being able to do that, these links will take you to those forms. And if you speak a different language than English, they have links to those types of forms as well. With that, I'd like to thank you for your time and your interest, and we'd be happy to hang on and answer any questions the group may have.
We do have a question from Cassie. I think I might need you to clarify your question, but typed in, how does this compare to a DNR?
So I understand a DNR to be a do not resuscitate order, meaning that after you have passed, they are not to take extraordinary measures to return you to life. A living will is before you pass. In other words, do not give me any measures to prevent or delay my passing. A DNR is subsequent to that, which says that after I pass, please do not attempt to revive me. The living will is very isolated to not delaying incoming death, for lack of a better term. A living will in existence should prevent any resuscitation efforts afterwards, because that would be directly contrary to a living will. Catherine, do you have more to add from the power of attorney perspective?
I don't think so.
So, what I would suggest, if someone is not terminally ill, but if they pass, does not wish to be resuscitated, that would be an additional directive that I would either include in my power of attorney for healthcare or convey to the individual I've appointed as my power of attorney for healthcare, so that they're aware of what my wishes are in the event such a circumstance would occur. Good question, Cassie. Does anyone else have any questions?
We do have a couple questions here. How many people may think of a will as a last will and testament? How are these different from living wills? Does one document hold more legal weight than another?
They are significantly different. They are both enforced by the law. Their goals are entirely different. A living will relates to a living person who has a terminal condition making a decision as to what kind of medical care they're going to get towards the end of their life and whether or not it's to prolong their life. A living will and testament, or a will and testament, is a person's decision about how they wish their property be disposed of after they're no longer alive. And for that, I would suggest you contact legal counsel such as Catherine. She's excellent at this work. She can help you work through those problems. But if you are looking to take care of how your property will be disposed of after you are no longer living, that's a will and testament. If you are looking to determine your health care because you have a terminal condition and you want to do it while you're still alive and can make decisions, that's a living will. I apologize that those terms are confusingly similar.
Another question for you. Living wills and power of attorney allow people to have their wishes outlined and respected when that person cannot articulate them. Can there be instances where a power of attorney or living will don't cover a person's wishes?
Well, I'll talk from the living will perspective, and happy to have Catherine chime in on the POA. The living will only go into effect if you have a terminal condition, it's been properly filled out and witnessed. So if you have a living will that hasn't been witnessed, you have nothing. So it's important that you follow the legal minimum requirements. Two, you need a healthcare professional who will honor and respect it. So it's important, while you're still of capable, sound mind and body, to convey your wishes and your living will to your healthcare provider so they have an opportunity to inform you if they will or will not be able to comply with that directive and can lead you or refer you to someone who otherwise will honor your wishes. With that said, that's how enforceable they are. The healthcare provider should follow it. The law requires that they do so, and if they refuse to do so because they're healthcare providers, they should send you to someone who will. Catherine, how about POAs?
They allow you to specify what powers you want to give your power of attorney, the healthcare power of attorney basically hands over everything and then lets you limit it from there if you want. So, like I kind of said in my presentation, it's similar to how much power a parent has over their child's medical decisions, but you can specify in the power of attorney that you do not want to allow them to make XYZ decision. And in the property power of attorney, you can just cross out powers that you don't want them to have. And you can specify anything that does not appear in the statutory form that you want your power of attorney to be able to do for you. So it should cover pretty much everything you want them to have the power to do. But it's also important to speak with the person you're giving this power and make sure it's clear to them what your wishes are and how they're reflected in the documents.
Catherine, is it fair to say also that because you've now given this authority to that person, they could choose not to exercise it or make the decision you would if you could?
Can
In
you
other words,
restate that?
if I wanted a DNR, but the person I gave my POA to has the authority to make that decision, and they decide that I was dumb, they could proceed to attempt resuscitative measures, couldn't they? That's the authority I've given them through the POA. So,
Unless it specifically says in the document that they do not have that power. Yes, that is true.
so it's important to remember with POAs that when you give that authority, you are truly ceding your own discretion if you are unable to articulate it. So, one, make sure you're very comfortable with the decision that person can make, or two, don't appoint that person as your POA. It should be someone you can trust to make the decisions you would want to be made. See, there's a big question that popped up.
The question is, when it comes to a power of attorney, specifically considering the LGBTQ plus community, do other states have to respect your POAs? For example, if Roe v. Wade were to be overturned and LGBTQ plus marriages are no longer recognized in, say, Texas, and we were there as a same-sex married couple and got into an accident, would Texas have to recognize my wife as my POA?
My understanding is that if it's a validly completed power of attorney, now it's possible that there might be a slightly different rule in a different state. Like, for example, in Illinois, there only has to be one witness to your power of attorney document, and it's possible that another state might require two witnesses or something like that. But my understanding is that as long as it is a legally valid document, it has to be honored.
I agree. I would say further that the status of spouse or partner is irrelevant under most states' considerations of powers of attorney. You're appointing a person, not a status in a relationship. To echo Catherine's point, the the state law at hand is going to be most important. Most states are very similar, but if you live in Texas, your best bet is to review Texas law and requirements for powers of attorney and make sure the one appointing your spouse complies.
So then to follow up on that, because you mentioned like if Texas needs two witnesses or whatever. So if we come from a state that doesn't have that and you go to Texas where it requires that, can they claim that that document is invalid then and not legal?
They can. The only way a document is enforceable under the law is if it complies with the law, and each state has its own version of that. So if you start off in Illinois with something that works well, great. But if you move, it's time to double check the laws there and make sure that what you had in Illinois will be sufficient in the current state. And if it's not, fix it.
Well, yeah, and that kind of answers her follow-up question.
Maybe.
Perfect. So I have a couple more questions for you. A lot of these are kind of relating to a case that happened in 2007 as a reference. So I'm just going to kind of read them, and then there'll be a couple follow-up in reference to that case. In 2007, Lisa Pond suffered an aneurysm. Her partner, Janice Langben, had a power of attorney and was designated as Pond's healthcare proxy. Yet Langben was not allowed to be by her partner's side when Pond passed away. Throughout queer history, same-sex partners have suffered treatment like this. First question in relation is, how can same-sex partners today ensure that they have their living wills and power of attorney respected? What protections are provided by state law versus federal law?
Well, that's a great question. The most important thing you can do is work in advance. While you have friends, while you have family, while you have your own competence and health, notify as many people as possible about your wishes and desires for healthcare when you are unable to articulate them. Most importantly, if you are engaged in a terminal situation, you already have a healthcare providing team. If that's true, convey to them your wishes. If the state law allows them at all, they will support and respect them. And if they feel they cannot, they have a medical and a legal obligation to tell you that and to get you to healthcare providers who will. So, the most important thing you can do is act in advance before you're unable to act. That said, I'm aware of no federal law that applies to these things. They are governed by the states, and therefore they are state specific. So, as we talked about with respect to moving an Illinois power of attorney to Texas, it's important that you recognize the state you live in may not comply with requirements of Illinois law or have different regulations. Make sure that you check every one of those boxes. And if you want to be doubly sure that you're doing it right, I would consider consulting legal counsel. That said, if you've done what the law says and your team is well informed and has met their obligations, then you should be well provided for. The case that you raised from 2007 sounds disconcerting, and it is not the way I would expect the law to be followed in the state of Illinois. Catherine, do you have more to add?
I was just thinking the same thing about federal law, but also they're legally required to respect your powers of attorney. So if a medical care provider is not respecting your power of attorney, they are breaking the law, and there can be consequences for that. So
Well, that kind of answered the second question that I had for that, which was just, if it's ignored, what are some of the legal recourse that the person with the power of attorney can take? But it sounds like there is some that they are kind of on the hook to where they can have legal recourse taken, which is nice. So a follow-up question again for the same case. It's more with them being designated the healthcare proxy. How is that different from having a power of attorney? Like, what causes the differences, but like the details of the difference between those two? um, yeah, what's the main differences that we find between something like a healthcare proxy and a power of attorney?
Could you share what you mean by healthcare proxy?
It's a good question. This is me reading some notes, but the person was designated as their healthcare proxy when they were denied and turned away from being there.
I see.
But
My
healthcare
thought,
proxy, if I can,
that's okay.
yeah,
Catherine,
legal document that allows you to appoint someone you trust to make medical decisions if you're unable to do so.
that sounds a lot like a healthcare power of attorney. In fact, it almost sounds like it's a different name for the same type of directive or document. What we have with a healthcare power of attorney that I don't know about a healthcare proxy is legal enforceability. If you have met the requirements of preparing an appropriate healthcare power of attorney according to the statutes of Illinois, that is a contractual and legally binding document healthcare providers must respect. I imagine a healthcare proxy is something where you can write it on the back of a napkin and say, I wish John Smith would make all my decisions for me. And you know, that might be persuasive to your aunt or your uncle. It is not a legally enforceable document. All kidding aside, though, my suggestion would be that you not aim for healthcare proxies or similar documents, but you find the equivalent of a healthcare power of attorney in the state you live in, and you abide by the requirements of the statute so you enjoy the protections of the statute.
Lovely. Okay, well, I mean, that's everything I have in regards to that case. We have another question that came in through the chat.
Wonderful.
How do finances factor into wills and POAs? For instance, if someone wanted to have a living will, a will for property, and POA drawn up, what could someone expect to pay for it and to be legally binding?
I think that depends on what a lawyer answered, depends, but it depends upon how many things you want to be covered by that, how specific you want to get, how many assets you have, that kind of thing. Because a will, not a living will, but a will and testament can be a very lengthy document with a lot of beneficiaries and discuss a lot of property. And most lawyers charge on an hourly basis. So basically, again, a lawyer answer depends on how complicated it is, on how long it would take, and therefore how much it would cost.
If I could add on, Cassie's question following up is, can you do it yourself, essentially? And the short answer is, yeah, you certainly can. The state of Illinois, especially, is really user friendly to people who live here. They provide a very clear statute. It's relatively easy to read and understand. They provide forms that are really easy to fill in the blanks for and qualify under the statutes that apply. So those links that we provided in our PowerPoint will be super useful to someone who wants to do this more as a do-it-yourself project as opposed to one where you hire a lawyer. Our suggestion, though, is that you consider consulting legal counsel if it gets complicated, if you have multiple heirs, or if you have a significant amount of property. Because while you can handle it yourself, there are tax beneficial considerations and there are statutory defaults that occur with respect to distributing property to your heirs that maybe you don't wish to follow, in which case it gets significantly more complicated rather quickly. Most lawyers who do this kind of work, just in case you're interested in it, charge by an hourly rate, and the level of complexity or cost is going, I'm sorry, your cost is going to depend on the level of complexity that goes into this. Most lawyers who do it have their standard form of questions for you to fill out, which will help streamline the process and help you organize your thoughts on how you want to address those things. But I imagine most people who want to do a will that have a relatively basic estate and want to do these other things are somewhere between $1,000 to $2,500 is a fair estimate for life planning. Again, there's a great range there, and to echo what Catherine says, it depends on quite a bit. But I think that's a fair assessment if you go to a lawyer who does this, what you might expect to spend.
Okay, love it. Compliments from Cassie saying it's an awesome explanation.
I see another question. Sorry to interrupt.
No,
That
absolutely.
wants to know if you come from a different state to the state of Illinois, what would that look like and how difficult would it be? Well, first, I'd suggest that maybe you click on the links in our PowerPoint slide and just take a quick look through those statutes or forms that Illinois provides. And if everything they have is on your form, check done. If you see that there's differences between them or there are blanks in the Illinois form that aren't filled in on your form or vice versa, and you have questions or concerns about those, you might want to give a quick call. If it's just a living will and it's just a healthcare power of attorney, you can probably schedule a 1 hour consult with an informed attorney who can help walk through those forms with you, identify the differences or missing parts from Illinois' perspective, and fill them in. So I imagine that'll be somewhere between $200 to $300 in just a 1 hour session. It depends on the attorney and the level of skill or qualification you're looking for, but I think that's a fair estimate.
I love that. So if someone was looking to begin this process, what is the for the wills, living wills, what can they expect the process to be? Obviously reaching out to an attorney, but like what can they kind of expect going through this?
Well, from the living will perspective, if you were to come to me to talk about this, the very first thing I would do is try and figure out what your goals are, what your concerns are, and where you're at in life. Are you just planning well ahead, well before you have a terminal condition, or are you worried that something might happen in the next 24 hours or 7 days? Those are different levels of concern and they require different considerations. And after we figure out where you're at in life and what you're looking to do, we talk through it. Most likely, what I do is give you the statutory form and ask you to fill it out with me. And then we would talk about various considerations or questions you have. It'd be a real non confrontational, relatively easygoing situation if it weren't for talking about mortality and those things. Um, but no one who has these concerns should put off addressing them because they're worried it will be a complicated process, especially if you live in Illinois. Again, the state is extraordinarily friendly to its residents who have these decisions to make, and they go out of their way to try and make it as easy as possible. So, whether you hire a lawyer or not, if you have these concerns, I urge you to take some time to work through at the very least forms.
So between power of attorney and living wills, uh, do you ever find that they contradict each other? And if so, is there one that trumps the other, or how are those possibly resolved?
Well, my understanding of living wills are that they are your declaration of what you wish, but those powers are cumulative. And if you have not restricted your healthcare power of attorney from making decisions in contravention of your living will, they would be authorized to essentially rip up your living will and choose to disregard it. That's part of the discretionary choice you gave to the power of attorney. So maybe another way to say that is your power of attorney can trump a living will. That said, your living will still articulates what your desire was at the time you were able to make it. And if you've appointed a good healthcare power of attorney, they should absolutely consider that in making their decisions. Catherine, well, I stepped on your feet. Sorry about that. Did you have more to add on the healthcare power of attorney side?
I actually think you gave a perfect answer.
I get a gold star later.
Okay. Well, I don't have any other questions I see coming through. Um, but I do want to ask if people want to, obviously, we have your links and everything that you've posted. But if anyone wanted to reach out to you or anything else, oh, we do have another question in. Is it common in Illinois for an attorney to act as an executor of our wills?
An attorney can do that. That sounds costly to the estate because attorneys will still charge their fee for doing that. You can have co-executors. You can request that they consult with an attorney. So you can also hire, most banks have trust and estates divisions that have professionals whose job it is to administer trusts and wills. There are lots of options. An attorney is one. I would suggest that instead you consider making an executor someone you trust who's a responsible professional, and you provide in the will that they can and should obtain legal advice with respect to their consideration. And then you can reduce the cost while ensuring things are done very well in answer to the question that came in. I think you were going to ask if people were interested in following up with this, are they welcome to contact us? And absolutely, we're here to help. I
Okay.
believe Catherine prepared a handout for everyone with respect to her particular portion of the presentation. Both that and our PowerPoint slideshow will provide information about how to contact us here at Miller Hall and Trades.
We do have another question that has come in. What is the advantage of a trust, especially if there is a high functioning autistic person involved who wants to keep their solidarity?
Okay. Well, what I understand this question to mean, solidarity makes sense. It's when we're all together and we keep strong. I think this question might also be talking about autonomy and wanting to make decisions for themselves as opposed to a guardianship or something similar where other people are making decisions for them. There are a couple ways we can go into trust, and I think that's a little beyond the scope of tonight. And we can certainly talk about doing another presentation regarding regular wills, trusts, and estates. I think there might be some fertile ground for that. But the short answer is it depends on what your goals are. A trust is a way to set aside, gotcha, yes, autonomy. Um, that relates to the decisions that are going to be made with respect to the corpus of the trust or the money that the trust represents and protects. Most of the time, trusts are for two main reasons. One, you want tax preferential treatment. And two, you want to dictate how certain money will be used for the benefit of others. Both of those are significantly complex legal documents that I suggest if you have specific concerns. We're now into the territory where you'll probably want to seek legal advice with respect to those. But it's possible to have a trust that allows an allowance or something else along those lines and gives that money directly to the beneficiary and allows them to spend that money as they will. The autonomy is still there, but what they don't have is control of the corpus. It's no different really than what a rich parent might give their children. They put the money aside to make sure their children, while they're young, can't spend it all. The trust can also have an opportunity to dissolve or give the money directly to the individual beneficiary at a certain point under certain considerations or circumstances. There's a lot that goes into it. And, quite frankly, we just don't have the time for it tonight in this presentation.
Yeah, I mean, that definitely is something that we will reach out and speak with you, maybe on doing another follow up with.
I will be sure to be in a place with a better internet connection when that one starts, if that's how we go.
Yeah, and I will. We can go ahead. I don't see any other questions coming in, so
Okay.
I guess we can go ahead and get this wrapped up. But if you want to send us the information, we can make sure we share the information on POA Proud. We will have this video also. It's being recorded, so that way we can have it as a resource that can always be watched again at a later time. But other than that, is there anything that you want to plug, like any connections for like emails or anything like that that you would like to share?
Catherine.
I'm giving you my email.
Well, maybe not the email, but like I don't know where I'm going with that. Anyway,
Well, what I would say is again, we did share ahead of time, and if you need us to submit it in a different way, that the full PowerPoint that Catherine and I worked from tonight, importantly, has links right in the middle to every one of these advanced directives. So you can look up these forms and fill them out yourself as soon as Peoria Proud can make them available to you. Also shared today was our handout. And it looks like Cassie would like to point out the Trivia Night 2025 is May 22nd. More information on the Facebook page.
Yep, trivia night coming up. It's going to be a night of fun. But yeah, all that information can be found on Peoria Proud's Facebook page under the events. And if there's any questions, I'm sure that they'll be able to reach out and we'll make sure we get your information shared. But other than that, I just want to thank both of you for tonight and sharing your knowledge and helping to illuminate this weird and tricky subject for a lot of us. And you've really helped to make it a lot more less scary and a lot more accessible,
Good.
I think. So
Good.
Any other final thoughts or comments?
Personally, I thank you for having us on.
Thank you.
Okay, well, with that, we will go ahead and end this. Thank you all for joining us.